see us, you didn't see us down. As far as we could still remain a constitutional court that is dealing with child-related matters, and child-related matters, we are a little bit more informal. We could have tried to have been more on one level, but our courts made in a manner desks of them are built on. So that is why we're still sitting up here. So for all intents and purposes, as it still remains a child-related matters, I would like to remind each and everyone, including the media, that names of the children, ages, where they are from, what schools they go to, should not be recorded in the public. It still remains information that needs to be confidential and private. All right. Okay. Um, Led is applicant is also not present. He's suing on behalf of his son. So himself and the son are not present. We are of the view that they would be of the child. Not. All right. Um, Now to the Attorney General. Late yesterday, one application was without notice, another was with notice. Our first with the without notice one, as that was dealt with as a chamber application yesterday. We will make a written order for both applications, but I want you to highlight the issues that we've indicated in those two applications. For the first one, for the application to extend time and allow you to fill in our arguments, the court carefully reviewed the application but dismissed it on the following grounds. The court was going to be addressing. Therefore, the AG's office and officers had knowledge to have allowed draft skeleton arguments in preparing authorities for the court. Secondly, the court does recognize that applicants did not follow or obey said order as they filed their submissions on 18th and 20th January respectively, which for all intents and purposes cannot be considered a major delay. The AG's office had from the 20th of January to 14th of February to have worked on their documentation. The court was extremely surprised that yesterday, around 4 p.m., the Attorney General's office sent this application. Honestly, the court's impression of the AG's office when it saw this application was that it was just a delaying tactic, but made so without this total regard of the court, with total disregard to the court. Thirdly, incidentally, at its prior meeting, the court yesterday, the court had having noted that you had not filed, but so that you could ably respond to the issues that were being raised by the applicants as well as amicus. Nevertheless, you are allowed to file skeleton arguments within 7 days, and that is 25th February 2022, and that time will not be extended again. Dealing with the second application, can we find out from you what time? But you should still be able to give me those emails. Just can I get confirmation from the applicant? What time were you emailed that application? 6 minutes to 7. And second applicant, what time were you served? Through Council Jose. I was not served directly any of the applications, unless I missed it somehow. But I don't recall either through email or WhatsApp receiving the same. You said you did serve them. Let me hear you. Having heard what they said, having as it will help us determine. Maybe let me make it easier for you, counsel. The reason why I asked you is because for all intents and purposes, we figured you served us that application at 4 o'clock. If you had served even the other parties, the court's decision was going to dismiss it. And I think it still remains the same. Because first and foremost, you have failed to have complied with any of the orders under the CPR in terms of necessary notice. You, under Order 10, Rule 6, the application needs to have had 2 clear days service on the other parties, including the skeleton arguments under Order 20, Rule 1. For the number of issues which we believe the court needs to address individually, it will address them in a written order, including its final decision of dismissing that said application. We are about to proceed. So if you have anything, raise it now.
You accept the order admitting Mika Skari on Friday afternoon hours.
You were served by whom?
It was sent by the Assistant Registrar, His Honor Carter. So, having been served on the whole first day, and at the moment we finished, that was when we finished. So, looking at the timing which we were served with the order itself, it was practically impossible for us to comply with the 48-hour rule, 2 days rule, as provided.
That is the order of the court. Admitting amicus. That's the one you're talking about.
Yes.
Okay. So you failed to comply. Is there any reason why you could not ask for an agent application, even on Friday when you received it, or made a notice that you intend? Because even that notice did not come. You must have known that you wanted to address it on Friday when you received it.
In fact, I did indicate to the Assistant Registrar who served on me that my home village attending a funeral, and Council Masanja was attending to matters in his.
But the Attorney General's office is a huge office. I've worked for the Attorney General's office.
Yeah, of course.
Two of you here.
Of course, but files are allocated to specific individuals.
But if you were going to address it, you had Saturday to indicate to the court, you had Sunday to indicate you want to make an application. And Monday morning, you've managed to email us through or out. You could have done the same. If you intended to have issues with the said order. You emailed us at yesterday at 4 o'clock when court was coming today.
Yes, my lady. My apologies for that, but I will need to send a complete application indicating the grounds. That's why we had to.
Preliminary, which notice could have been done on Monday, early. If you have, that's why I asked, you have any issues, raise them now, otherwise we're about to proceed. Yes.
My lady, my lord, you had indicated that you were inclined to dismiss our application, but because there were some issues that you want us, you still felt should be addressed, and now you are saying that you want to
No,
proceed.
I said we were inclined. We are. That's what I said.
All right.
I was waiting for you to on the notice and everything. That's why I said we were inclined. But then we didn't get any. We didn't get anything from you. That's why we proceeded to dismiss it. But I still think.
Much obliged, my lady. Um, because we had filed two applications,
Mhm.
one seeking an enlargement of time to file our processes,
Mhm.
which this court has given us 7 days to do so.
But I've asked you to respond to the points of law in court today.
Yes, I was. And then the other application,
Yes.
we would not be able to proceed, my lady,
Mhm.
because some of the documents and processes we were given yesterday. So some of the processes actually started coming to us from
Mhm.
the office Friday.
Which ones?
All the amicus documents.
Mhm.
And I think for most of them, we don't have the, we only have the applications to be added as the party,
They're not added as.
or rather as amicus.
Mhm.
Yes. So we don't substantive.
Yeah.
And even if we're asked to simply make our representations on a point of law, I think it will be a tall order in this regard because in total seven parties, you could say. Yes, I was saying there are two parties there. There are the amicus as well. So that's why I was saying that it's
Okay,
seven.
okay.
Yes.
And
And for that reason, that's why we're saying that even some of the documents were served on us on WhatsApp yesterday. So that's why it's a bit difficult. But on the decision to dismiss our application, which we're seeking to set aside the order allowing the amicus to join proceedings, I would seek, first of all, clarification on the exactness of the words that the Honorable Court has used in terms of is it the dismissal outright, flat, and he had also said that there will be a written order to the Honorable Court, my lady, my lord.
so my order was complied, and under order 2, you have every right to dismiss your application, and that's what we've done. Yes.
My lady, my lords, this honorable court, having dismissed our application to set aside the order on admission of amicus curiae as defendants,
Sorry, as what?
as defendants.
Did we admit them as defendants?
No,
Did you read
as no,
our?
no,
Did
I'm
you?
saying us now.
Okay.
The Attorney General
Okay.
and the Inspector General of Police as defendants in this matter
Mm-hmm.
are aggrieved by the said decision which this honorable court had just made. In that regard, we are filing a fresh application before the Supreme Court of Appeal.
You are filing.
Yes, we intend to file before the Supreme Court of Appeal.
Mm-hmm.
Therefore, my lady and my lords, I'd like to make an oral application under the 10 to have the present proceedings stayed pending the determination of the Supreme Court of the fresh applications which we are making that have been dismissed in this honorable court. Um, my lady and my lords, it is therefore our humble prayer that these proceedings be stayed.
Counsel, AG, I would like you to engage us on the order you are relying upon. Mm, my understanding is that Order 10, Rule 9 on oral applications says that the court may allow an oral application in a proceeding to be made where the application is for urgent relief. B, the applicant undertakes to file an application in a proceeding within the time directed by the court. And C, the court considers it appropriate. 1, because of the need to protect persons or property. 2, to prevent the removal of persons or property from Malawi. Or 3, because of other circumstances that may justify making the order asked for. So I don't know, even in your application, I don't know whether it can be said that you have complied with the requirements of that order and rule.
Much obliged, my lord. My lord, we believe that our application passes the test contained in Order 9, Rule 10. 1, the application is for urgent relief, and
Before you proceed, did we allow you to make the application?
He went straight ahead and made and didn't even seek the court's leave.
The court may allow. Did you make an application that you wanted to, and we said yes, proceed?
Counsel, you're making a lot of assumptions, and you're expecting us as a court to just follow you.
Counsel, did you make any undertaking to file written documents? We didn't even give you the time in which you're going to. I don't know.
Yeah, let's hear back from you.
The honorable court interjected, my friend, my colleague here. It's just a slip of the tongue with the use of the words that.
No, it wasn't, Counsel. Let's be honest.
He made it.
We speak up the applications. Let me read what he said. Should I read verbatim how he made the order? The application he made.
The first one.
Yeah, no, the one that talks about he wants to file a fresh application. Did I not interject when he says we are filing? And I said, you are filing. And he said, no, we intend to file. Should I read exactly how he made that application?
Um,
Let's for all intents and purposes, we all grown-ups, let's be honest about how we're addressing the court and how we're doing it. Because you are doing things without even seeking the court's leave. And that, for intents and purposes, is disrespectful.
much
And don't
obliged, my
add
lady.
things that were not there before.
I was referring to the time that he stood up the second time.
Okay, because
That's where I was referring to, my lady. Thank you so much. My, my lady, I think you would start from the top, as in we'll seek to rectify the earlier representations.
yes,
The court, having dismissed our earlier application, we would want to seek leave and be allowed to make an oral application in terms of Order 10, Rule 9.
yes,
And the reason that we want to make this oral application is that we are asking for an urgent relief
yes,
in the sense that if this court will be going in, will be going into the substantive matter,
yes,
having no time at all respond to the documents that were served on us on Friday and yesterday. And we've opined that this would be unfair. So the relief is urgent in the sense that in as much as the matter was scheduled to come today, well, that's the urgency of the relief sought. And I think I've already discussed on the prejudice that the defendants would likely suffer if we're not granted the application. And we would also undertake to file um, the application as well within the time that the court would direct.
yes.
find that um, the circumstances in this particular case do justify this honorable court sitting as the High Court empaneled as a constitutional court to allow and to hear the position of the Attorney General, the Inspector of Police, as well as the Director of Public Prosecutions in this matter, dealing with the provision of the Penal Code. So that is the prayer that we make, that this court would allow us to proceed in that manner.